tight. Hold my baby squid, keep them out of sight. Talking about my life, government stay away. Watch me drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my baby, protecting with my no government intrusion. I control my life.
Hey guys, it's Squid. Welcome back to the channel. Second stream of the day. Thanks for all of you guys who showed up for my workout stream this morning. I am exhausted, but I know it's going to be good in the long run. Short-term pain for long-term success. Anyway, today it's Sports Ball Monday. It's been crazy busy this morning, like folded laundry. The little is down for a nap right now, so if you hear screaming, it's because she woke up and I'm not there. Hey Flash fan, how are you? So it's Sports Ball Monday. We are going to get into this. I just forgot to actually open the documents because I've been so busy this morning. So there is quite a few motions to dismiss because there is multiple plaintiff or multiple defendants. Each one of them put in a motion to dismiss. We are going to look at the motion to dismiss by Marcus Castro Walker first, which is the Florida staffer. Not necessarily the most involved or the highest publicity. Yeah, you the only one here. It's weird. Like, who else is streaming right now? Because, like, there is nobody here. Well, you know, it is what it is. I appreciate you being here, Flash fan. Yeah, that's rare, huh? Two people or one person. AJ is. And then who else? I didn't get any notifications for people, but then again, like YouTube doesn't give me notifications much anymore. Oh, the Wilborns. Good Logic is live right now. That's weird. For him to be. Yeah. I know. Hey, Debbie. Yeah, this is weird. But anyway, we'll just get to it. I might cut this video down into just the emotions. But getting into the sports ball, we are going to look at all these motions to dismiss because they were just weird. Like, this is just, you could have figured this out without being sued. Like, you thought you were going to get away with stuff and you just didn't. Dave Neal just finished. All right. I forget Dave Neal goes live around this time. I just forgot to save it to the right folder. There we go. That was my problem. I was looking for it and I didn't save it in the right spot. You know, I actually put it where it's supposed to go and then I can't find it. It's funny how that works. Dave Neal does a lot of Bachelor stuff. Not really my scene, but he was the one who was first to get involved in the Laura Owens and Clayton Echard debacle. We disagree on some things, but that case he was the first to do it. Hey John. All right, we're gonna get into this. defendant Castro Walker, which is the Florida staffer, not the head coach, not the person that has the money, just Jayden's initial contact with and the person he probably talked to the most in the recruiting process. All right, defendant Castro Walker's motion to dismiss an incorporated memorandum of law. Castro Walker moves under federal rules of civil procedure 9B and 12B6, as well as Florida statute 768.28 9A, to dismiss plaintiff Jayden Rashada's complaint, stating as follows. Introduction. Jayden Rashada was a high school football player being recruited by the University of Florida, and Marcus Castro Walker was the director of player engagement and NIL at UF. Because Castro Walker had a prior personal relationship with Rashada's father, Castro Walker was one of the individuals at UF specifically tasked with recruiting Rashada to UF. Would it be nice if I shared my screen, right? It didn't want to share the first time I did it. Hey, it's always fun when your screen works like it's supposed to. Hey, Slug, how are you? Wait, what? Nope, not going there. I'm just going to ignore that. Just going to ignore that one. All right. Accordingly, the sole goal of UF, acting through Castro Walker, was to have Rashada accept UF's scholarship offer and play for UF. Under NCAA rules at the time, I'm just going to say Florida because it's easier for me. Florida was not allowed to provide money or other financial benefits to Rashada in order to induce him to accept their scholarship offer, in a fact of which Rashada and his legal representatives were fully aware. As made clear in the complaint, everyone knew that any additional financial benefits Rashada would receive for his name, image, and likeness would have to come from source outside of Florida. Yeah, we're going to go with a no on that one, Slug. Thus, as UF's Director of Player Engagement and NIL, it was clear to everyone involved that Castro Walker could only take two actions in compliance with NCAA rules. 1, offer Rashada a scholarship to Florida, and 2, tell Rashada's representatives that they would have to speak to independent outside sources regarding any potential future NIL benefits. Which is funny because he's the one, according to Rashada's complaint, that introduced him to Velocity Automotive's owner. I'm not saying that until I'm not saying that name unless it's super chatted. Y'all, if you know, you know. Both of these acts were clearly within the course of and scope of Castro Walker's position at Florida, and both were entirely consistent with Florida's goal of getting Rashada to accept its scholarship offer. Hey, Harry. Ultimately, Rashada accepted Florida's scholarship offer when he signed a binding NCAA letter of intent on December 21st of 2022. Both Rashada and Florida entered into that scholarship contract voluntarily and with informed consent, proving that Castro Walker did in fact have authority to offer the scholarship on Florida's behalf and that Florida approved of him doing so. Castro Walker had accomplished his task. Basically, is he saying that, hey, all I had was scholarship money. That's all I could offer. So the NIL stuff doesn't involve me. He is trying so hard to like make him like that's a y'all problem, not a me problem. And it's like, judging by the quotes that were in the amended complaint, he had a lot more to do with this than just a scholarship offer. And you don't get Director of Player Engagement and NIL unless you have your hand in it. The NCAA might not allow you to do it, but we all know that schools have been paying players for years, even before NIL was a thing. So hiding behind the NCAA is pretty sad, in my opinion. Argument and memorandum of law, sovereign immunity. This should be good. Before analyzing whether the complaint is deficient in its factual pleadings, the court must determine whether or not it is even proper for Marcus Castro Walker to be named party in this action at all. Oh, this should be interesting. Even if we accept the worst of Rashada's false allegations as true, that Castro Walker conspired with others to trick Rashada into accepting Florida's scholarship offer by dangling the carrot of future NIL benefits upon signing, the fact remains that Castro Walker would still have been acting solely within the interests of Florida in achieving its goal of convincing Rashada to play for UF. Wow, that's sad. Hey, Jen. I mean, doesn't that just make the University of Florida look like such a great place to go? And if you know me, you know I hate the University of Florida with a passion. However, like, so lying to him about dangling a carrot of future NIL benefits is still within your interests of Florida? Just to convince him, that's low. That is low. Like, I don't know if Rashada should be suing. That's not my place. But like, the motion to dismiss so far is pretty sad and kind of pathetic and grasping at straws. There is no world in which Castro Walker was doing anything to prevent Rashada from attending Florida, nor was there any time in which Castro Walker was acting in his individual capacity to do anything contrary to the interests of Florida. Once again, not the point. Not the point. Getting him to go there and getting him to go there for almost free is well within Florida's interests. It's just not right or ethical. There's this ethics thing again. Like, just because it's within Florida's interest doesn't mean it's ethical. I just don't understand it. In fact, the complaint is completely devoid of any such allegations. Yes, because you're missing the point, and your lawyer is too. So why then has the plaintiff's counsel tried to perform legal gymnastics by suing Castro Walker individually instead of simply suing UF for any alleged torts he may have committed in the course and scope of his employment? It can only be because the plaintiff is desperately trying to improperly avoid the caps on damages that come with sovereign immunity, which must not be allowed. This is a... Yes, Florida sucks. And it, like, I thought Florida sucked before, but now I really think Florida sucks. Like, this dude's lawyer is, like, making Florida look less than an ideal place to do business with in any capacity. Oh boy. Every alleged count against Castro Walker in the complaint is based in tort, and Florida Statute 768.289A specifically states, an officer, employee, or agent of the state or any of its subdivisions may not be held personally liable in tort or named as a party defendant in any action for injury or damage suffered as a result of any act, event, or omission of action in the scope of his or her employment or function, unless such officer, employee, or agent acted in bad faith or with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. If you remember, Rashada's complaint said in bad faith, every other sentence, bad faith, bad faith, bad faith. So the fact that the complaint states that the belief is that they acted in bad faith makes this, in my brain, null and void. the promise of NIL money to get him to sign the contract, but it not being the contract. This case has no merit. It may be scummy, but it's not illegal. And that's the gray area, because this is the first lawsuit that I have seen. It's probably not the first one out there of a failed NIL deal. It's just the first one that I've personally seen. And it does have some good points. And whether this actually goes anywhere, as far as Jayden Rashada getting any NIL money or any damages from this, I don't see really happening. However, I do see the NCAA keeping a close eye on this situation and implementing rules so this doesn't happen. I don't know what rules. I'm not the NCAA. I can't speak for them, and I know they have their own shady business and shady dealings when it comes to money. And that's, yeah. Oh, yeah. But civil law, and that's what this is. It's a civil lawsuit. But I don't see this lawsuit actually going anywhere. I see the judge maybe I don't see it going to a jury trial. Let's put it that way. However, I do see the NCAA looking at this and making rules as to what you can and can't do with NIL money and these collectives, because collectives are a huge problem. So I see the NCAA looking at this and possibly making rules and implementing rules so that this doesn't happen. But this motion to dismiss makes Florida look less than stellar in any capacity. Scummy. Maybe not illegal, definitely scummy. But I think that's part of the point. Because a lot of people who file a lawsuit know it's not going to go anywhere and they're probably not going to get anything. However, it's the attention that it brings to possibly change something or prevent something like that from happening again. Once again, not a lawyer. That's just my layperson opinion and my sports ball lover opinion that the NCAA is going to do something to prevent something like this from happening again. Because it has not been sufficiently alleged or shown that Castro Walker acted with actual malice, Castro Walker may not be held personally liable or named as a party defendant, and the action against him must therefore be dismissed with prejudice. See, and that's the thing. The way the lawyer writes this is pretty genius, but pretty twisted and scummy. Because he says it's not been shown that Castro Walker acted with actual malice. He doesn't have to show that. He has to show bad faith or malice, not both. So there's that and or does not mean, we need to go back to like a 5th grade English class, or language arts or whatever you call that. But the way he writes it makes it seem like they haven't shown any malice. Well, that's not the point. It's bad faith or malice, not both. And malice never was mentioned in the complaint. If I remember correctly, that was, 5 hours of my time reading that. That was not, it was not malice. It was bad faith. So nice try. But once again, this part, if I were the judge, be it the judge is a lot smarter than me, but just reading the law and then reading what the complaint had said, this makes no sense. Courts apply a two-pronged approach when considering a motion to dismiss. American Dental Association v. Cigna, 11th Circuit, 2010. First, a court must, quote, eliminate any allegations in a complaint that are merely legal conclusions. A court must then take any remaining well-pleaded factual allegations, assume their veracity, and then determine whether they plausibly give rise to an entitlement to relief. Internal quotations omitted. A complaint that does not contain sufficient factual matter accepted as true to state a claim plausible on its face is subject to dismissal. Further, a dismissal is warranted under Rule 12b-6 if, assuming the truth of the complaint's factual allegations is a dispositive legal issue, precludes relief. Nitsky v. Williams, 1989. Castro Walker was at all relevant times the Director of Player Engagement and NIL at the University of Florida. And that title, like Player Engagement and NIL, if the university itself can't give you NIL money, then why do they have somebody that's in charge of player engagement and NIL? Make it make sense, or somebody explain that one to me, because like if they can't pay the players, then why do they have an NIL director? Just saying. Technically, however, Castro Walker was at all relevant times an employee of the University Athletic Association, Incorporated, a Florida direct support organization pursuant to Florida Statute 1004.28. Florida and the UAA are both, quote, state agencies and subdivisions entitled to sovereign immunity protection under Florida Statute 768.28. Plancher versus University of Central Florida Athletics Association, Florida, 2015, wherein the Florida Supreme Court held that the University Athletic Associations primarily act as instrumentalities of the state and thus are entitled to limited sovereign immunity under Section 768.28. That damn immunity. I hate it. Hate it. Hate it. I don't think anybody should have immunity at any time. Ugh. All of Castro Walker's communications with Jayden's representatives were conducted in good faith and within the course and scope of his employment position at Florida in an effort to recruit Jayden Rashada to attend Florida. Castro Walker occasionally passed messages back and forth between Jayden's representatives and others, but Castro Walker repeatedly made it clear to everyone that he was only acting as a conduit of information and was in no way acting as an agent or representative of any collective or individual other than University of Florida. Castro Walker knew that colleges were not allowed by the NCAA to use monetary NIL promises as inducements to convince prospective recruits to sign with their school. But that's, according to the complaint, that's exactly what he did, because he's the one who introduced Jayden to the dude. Walker repeatedly included the following language in his communications with Jayden's representative: "I refuse to be involved in prospect dealing." I would love to see those text messages. Nowhere in the complaint is it alleged that Castro Walker's recruiting efforts were outside the normal course and scope of his employment. Everything he is alleged to have done falls clearly within the defined role of a college recruiter. Accordingly, Castro Walker may not be sued or named a party defendant to this action because nowhere in the complaint is it alleged or proven that Castro Walker acted with level of malice or evil intent to take him outside the protection granted by Florida Statute 768.289A. And that's where they bring up the bad faith, like the malice. It's not, he never said malice. He said bad faith. Bad faith. And you say up here, all of his communications with Jayden's representatives were conducted in good faith. Well, your actions say otherwise. Your words might say good faith, but your actions deemed otherwise. And Actions speak louder than words, so they say. It's just so weird. Just so weird. Florida law shields governmental agency employees from liability and tort actions for conduct taken in the scope of his or her employment, but is introducing him to the owner of an NIL Collective. Is that technically in the scope of his employment? Shouldn't that be done by the head coach and or individually approached by these people, not introduced in a room on campus? That's just shady to me. And shady might be not be illegal, but shady is still shady as fuck. Hey, Mom. Oh. See Florida Statute 768.28. However, those employees have no immunity where they acted in bad faith or with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. Thus, courts must dismiss such claims unless the plaintiff makes a good faith allegation in the complaint that the public official either acted outside the scope of his employment or acted in bad faith or with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. Forrest v. Pustizzi, Southern District of Florida, 2017, quoting Brown v. McKinnon, Florida 3rd District Court of Appeals. 2007. In other words, at the pleading stage, a plaintiff must allege that the public official acted out of, quote, ill will, hatred, spite, or an evil intent. Evil intent, we could go with, yeah, immunity is corruption. Like, evil intent, we could go with the fact that they were trying to recruit a college quarterback who would make them a lot of money and possibly help Billy Napier keep his job, even though Florida is stupid and they're not firing him. But that's beside the point. And yeah, it's beside the point. Or that the official knew or reasonably should have known that his or her conduct would naturally or probably result in injury, and with such knowledge, disregard for the foreseeable injurious consequences. The question of whether an act was committed with malicious purpose, bad faith, or with wanton, willful disregard is not a question that must be submitted to a jury, but rather can be decided by the court depending on the facts. Prieto v. Melger, 11th Circuit, 2004. Determining that the Florida Supreme Court explicitly disavowed the proposition that the question of bad faith must always be submitted to the fact finder. The 11th Circuit recently addressed this issue in Coleman v. Ricardo, 11th Circuit 2022, wherein the court defined the level of malice required to overcome sovereign immunity or immunity protection for individuals, stating, okay, before I read this, the court defined the level of malice required to overcome the immunity. He never said malice. He said bad faith. Remember that bad faith or malicious intent? Not both. This dude is, well, they never said, they never talked about anything malicious. Yes, because you can have bad faith and not be malicious. Those two aren't mutually exclusive. And this lawyer is either really stupid or really tricky. And I'm not sure which one. He definitely writes better than some lawyers I know. Just saying. However, still not great. The first two exceptions of 768.289A in bad faith and with malicious purpose are synonymous with each other in Florida law. But are they, though? But are they, though? Like, just because one court agreed with you, I'm wondering how much case law is out there that shows those two aren't. Another way to put it is that Florida courts have equated both bad faith with the actual malice standard. The actual malice and malicious purpose exceptions apply when conduct was committed, quote, with ill will, hatred, spite, or an evil intent. We will refer to this Florida sovereign immunity carve-out as the actual malice exception. But are they? But are they? Like, are they under Florida law, or did you just find the one case that I need to read this whole case and figure out exactly what was said, because even case law can be taken out of context. Just saying. Having defined actual malice in regard to 768.28, the Coleman Court went on to clarify that the lesser standard of, quote, legal malice does not apply in such cases. Legal malice requires only proof of an intentional act performed without legal justification or excuse, and does not require proof of evil intent or motive. The district court erred in this case when it applied the legal malice standard instead of the actual malice standard, and determined that an arrest without probable cause by itself establishes that the officers acted with malice for the purposes of 768.28. It doesn't. Having determined that the lower court had not properly analyzed the actual malice issue, the court went on to say, we will go ahead and resolve the immunity issues now instead of remanding the case for the district court to do so in the first instance. See Hunter v. Bryant, 1991, explaining that it is important to resolve the issues of immunity from suit at the earliest possible stage in litigation. In conducting a de novo review, the Coleman Court found that the plaintiff's complaint alleged that police officers made repeated visits to his house prior to his arrest, and that this created a genuine issue of bad faith or malice. See, there's that "or" word again. Words matter, people. Words matter, so they say. And that the defendant officers were part of, quote, some kind of plan to unalive or capture him. These conclusory allegations and speculations, which are remarkably similar to the unsubstantiated conspiracy claims alleged in the instant complaint, were found by the 11th Circuit to be insufficient to create a genuine issue of material fact on the presence of malice, citing Glasscox v. City of Argo, 11th Circuit, 2018. Conclusory allegations and speculation are insufficient to create a genuine issue of material fact. Accordingly, the court stated speculation is no substitute for evidence, and ruled that the officers were entitled to sovereign immunity protection. Moreover, the court in Coleman went on to rule that even the act of battery would not automatically rise to the level of actual malice required to overcome sovereign immunity, stating, even assuming for present purposes that the officer's physical contact with Coleman during the course of his arrest was a battery, there is no genuine issue of material fact that the defendant officers acted in bad faith or with malicious purpose, or in a manner exhibiting wanton and willful disregard of human rights, safety, or property. Accordingly, the Coleman Court granted the defendant's motion for sovereign immunity protection. In the instant case, even a reading of the complaint in the light most favorable to the plaintiff fails to show any allegations of conduct that rise to the level of actual malice. If the act of battery cannot even overcome the threshold, then certainly none of the allegations against Castro Walker do either, because no reasonable jury could find that Castro Walker was acting with ill will, hatred, spite, or an evil intent. The case against him must be dismissed with prejudice at the earliest possible stage in litigation, which is now. I don't see the I don't see the judge dismissing this without more. Just I just don't. Especially with the I believe the judge would want to see like text messages and actual things, actual evidence. Just a thought. I would. I mean, I don't take people's words for it. I like evidence. Show me evidence. Even if mere allegations of fraud alone were found enough to make Castro Walker individually liable, the fraud would have to be played properly and sufficiently. In Parker v. State of Florida, Board of Regents, First District Court of Appeals, 1998, the appellate court found that a governmental employee's fraud was enough to protect the governmental employer from liability. In Parker, the governmental employee was accused of fraudulently offering a contract that included a pay raise to fellow employee and then never following through with the raise. That case, however, has one major distinction that renders it inapplicable to ours. In Parker, the governmental employee specifically argued that the governmental employee did not have the employer's authorization to offer the contract in the first place. Clearly, therefore, it was in bad faith and prima facie, and I've screwed that up, fraud on its face for the employee knowingly go outside the course and scope of his employment and make a contract offer without permission and consent of his employer. This case did not involve just an allegation of fraud. It involved an admission of it. In the instant case, however, the facts are completely different. Here, Castro Walker undeniably did have Florida's authorization to offer a scholarship contract to Rashada, as evidenced by the fact that Florida happily acknowledged and acquiesced to the completed contract upon its signing. Accordingly, the bad faith and actual malice that was so clearly evident in Parker is entirely lacking in our case. Absent such proof of bad faith, the court must dismiss the complaint with prejudice for all of the reasons previously stated. The plaintiff will be left with the clear and easy remedy of simply suing Florida directly for whatever torts their employee may or may not have committed while doing his job. 2. Fraud counts 1 through 3. A pleading need only contain a short and plain statement of the claim showing that the pleader is entitled to relief. The pleading standard Rule 8 does not require detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. Ashcroft v. Iqbal, 2009. A plaintiff must articulate enough facts to state a claim to relief that is plausible on its face. Bell Atlanta Court v. Twombly, 2007. I hope I pronounced those names right. I feel bad if I don't, but nobody pronounces my name right ever, so there's that. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct allegations. The plausibility standard is not akin to probability requirement, but it asks for more than a sheer possibility that a defendant has acted unlawfully. Threadbare recitals of the elements cause of action supported by a mere conclusory statement do not suffice. Thus, a pleading that offers mere labels and conclusions or a formulaic recitation of the elements of a cause of action will not survive dismissal. In addition, Federal Rules of Civil Procedure 9b requires a party alleging fraud to state with particularity the circumstances constituting fraud. This is interesting because I know it's been a week since we did anything with this case, but I'm pretty sure that this right here, to state with particularity the circumstances constituting fraud. I'm sure that I read in that 50 some pages, I read that more than once. The purpose of the rule is to protect a defendant's goodwill and reputation when the defendant's conduct is alleged to have been fraudulent. Wagner v. First Horizon Pharmacy Corp., 11th Circuit, 2006. This requirement serves an important purpose in fraud actions by alerting defendants to the precise misconduct with which they are charged and protecting defendants against spurious charges of immoral and fraudulent behavior. Zimba v. Cascade International Incorporated, 11th Circuit, 2001. Failure to meet the requirements, as we see done in the instant complaint, is a ground for dismissal of a complaint. Corsello v. Lincare, 11th Circuit, 2005. I applaud this lawyer's effort, but some of his arguments don't hold water to me. But, I'm not a judge. A false statement of fact to be ground for fraud must be of a past or material fact, not a promise to do something in the future. Bailey v. Covington, Florida 3rd District Court of Appeals, 2021. Hey, Christine. Nowhere in the complaint is it alleged that Castor Walker ever made any promise that Castor Walker himself would ever pay or do anything. Well, duh. Like, well, duh. But that's okay. This is just. I don't think this case will go anywhere, but I do think it has merit. I think that, like I said, the NCAA will be keeping an eye on this, but even in the light most favorable to the plaintiff, how sweet of you. All Castor Walker did was predict what he thought others would do. This is why the plaintiff made a futile effort to plead agency, apparent agency, and conspiracy theories, because without them, fraud counts against Castor Walker fail on their face. Well, I always say on this channel, like, I don't speak for anybody else and nobody speaks for me. Yeah, Flash fan, I can. However, all he did was predict what he thought others would do. That is not a place, and no one should be predicting what others should do. Like, you either know or you don't know. And I would, if it were me, I'd be like, I don't know what they're going to do. I would not insert myself into that situation by saying, this is what I think they'll do. No, I don't know what they're going to do. You have to talk to them. Don't insert yourself into a situation that has more money than you will ever see in your life. Just saying. Under Florida law, an agency relationship requires a, quote, acknowledgement by the principal that the agent will act for him, the agent's acceptance of the undertaking, and control by the principal over the actions of the agent. Marchizo v. Carrington. The complaint is completely devoid of any facts that meet these elements. In fact, the facts plead in the complainant contradict any such conclusion, as Castor Walker is clearly an agent for his employer, the UAA-UF, while defendant... He didn't even spell the other defendant's name right. Hugh is clearly an independent businessman with no affiliation to the university other than being one of more than 500,000 Gator fans worldwide. Well, isn't that the lie of the century? He has no affiliation to the university. He's a effing booster, but no affiliation. Likewise, Oh boy. And that's sad, or that's unfortunate and kind of wrong to assume that 500,000 people like Florida, because there's yeah. Likewise, Castro Walker was never an agent of the Gator Collective LLC. There are simply no showings of Castro Walker being controlled by anyone other than the UAF, which is precisely why the complaint should be dismissed on sovereign immunity grounds, as previously stated. The plaintiff has stated no facts that specifically prove an agency theory or even an apparent agency theory, but merely a bare assertion that Jayden believed that such a relationship existed. A belief is not a fact, and no such facts meeting the necessary elements were pled. The complaint must be dismissed on this basis. Moreover, a complaint also must not lump together all of the defendants in allegations of fraud, as we see done repeatedly in the instant case, Ambrosia Coal and Construction Company v. Pages Morales, 11th Circuit, 2007. The instant complaint is an impermissible shotgun pleading, in that it asserts multiple claims against multiple defendants without specifying which of the defendants are responsible for which acts or omissions. Weiland v. Palm Beach County Sheriff's Office, 11th Circuit, 2015. Thanks, Unhung Hero, for the $5 super chat. Oh, and I forgot today is January 6th. That's why everybody's live talking about that. And I'm so sick of anything related to politics right now, except for what's in our food. Then I'm like, Trump is certified by the Electoral College. Also, Hugh Hathcock. Not anything like that. But thank you, Unhung Hero, for ensuring that I don't work for free today. Appreciate you. The plaintiff clearly does this in an attempt to bolster its improper conspiracy and agencies theory, but such claims must be broken down and pled against each defendant separately so that they may be defended properly. Failure to do so calls for dismissal. I don't disagree with that. I'm not a huge fan of this lawyer. And honestly, I don't think this lawyer is his lawyer anymore. I think he has a new lawyer. The instant complaint also fails in that it improperly asks the court to assign scienter to defendants' actions using improper, and this is Latin and I'm going to screw it up. So don't laugh at me, but yeah, I'm not saying that because that is I'll have to get Siri to pronounce that. Time to mom shame the chat or set a goal that you'll say Hugh's name for every $10 in super chats. Well, one, there's only like 8 people here. And 2, for every $25 in super chats that I get, I'm eating one of these. So, in fact, you know what? No, I'm not going to do it. I'll do it off camera because they smell really good and I'm going to break them up and put them on a salad after I get done here. If the little is still asleep and I can eat. The plaintiff makes conclusory allegations of fraud and the defendant's mental state based solely on how the timeline ended and not on any supporting facts or evidence. Losey v. Warden, 11th Circuit, 2013. The mere fact that a marriage ultimately ends in divorce cannot be used in hindsight to prove that a party had fraudulent intentions when they proclaimed "till death do us part" at the altar years earlier. Well, that's an interesting way this chat identifies as a $25 super chat. Nice try. Nice try. I don't grift very often, but that's my grift. There is not a single fact pled in the complaint that truly evidences any degree of scienter on the part of Marcus Castro Walker, So the heightened pleading standards of Rule 9b require dismissal of counts 1 through 4. American United Life Insurance Company versus Martinez, 11th Circuit 2007. Wilding v. DNC Service Corp, 11th Circuit 2019. The simple truth is that overly optimistic promises are made every day in college football recruiting. And this right here is the heart of this issue that I think the NCAA will take a look at. And will use this lawsuit as reason to implement new rules. Because he says it nonchalant. Well, this happens every day. That doesn't make it right. Like, players are told all the time that they will be starting by their sophomore season. And that's different than money. Like, I'm sorry. Oh, you'll be starting by your sophomore season when you could get injured, when somebody could transfer in better than you. That is different than money. And for him to equate, oh, you'll be playing by your sophomore season, we'll pay you $13.85 million so you don't go to Miami. Two completely different entities. Or that they will win the Heisman Trophy if they play this offense. The statements that he's using here are like, yeah, I could tell Unghung Hero that he's going to win the Heisman Trophy next year. He doesn't even freaking go to college. If it doesn't play football, go to college. Like, you don't play college football, you can't win the Heisman. But I can tell him anything I want, and he could believe it as, oh, she told me I'd win the Heisman. I tell Mr. Squid all the time that no, I didn't speed home. That doesn't make it true. Just saying. Or that they will be a first-round NFL draft pick if they attend this school. But that's a little different than saying, hey, we'll pay you money if you go here. Because you'll be a first-round draft pick, there are so many variables. We're saying, here, we'll give you this amount of money and a car if you go to this college. It's tangible. Like, hey, Tammy, thanks for becoming a member of the Squid Squad. Tentacle Nation is the case, maybe. I don't like this. This is a stretch where one of my high school English teachers said, when I grade your papers, if I see stupid little errors or things that don't make any sense, I will look a lot harder, because if you make an error on something small, how many big errors are there? Here's the thing. When I read a pleading and there's a stupid argument, it makes me deep dive into the rest of it and be like, if this argument is that stupid and I'm able to figure out that this is that stupid without even and I can dismantle your argument without a law degree, what is the judge going to do? Oh, I was already a member. I just had update payment. Well, I appreciate you nonetheless. Opening the doors of the federal courthouse to every college football player seeking injunctive relief or specific performance of an oral contract when their dream doesn't materialize would only lead to a class of plaintiffs larger than any mass tort action on record. And here's the thing. This is where I believe Jayden went wrong, is nowhere did he ever in his complaint ever say that this was written down. This was all verbal and in text message. And yes, text messages can be introduced as evidence, but are they binding? I'm not a contract lawyer. Yeah, Tammy, I'm not, we've established that we's not reading that name without a super chat. And I will never say his last name unless it's in a super chat because y'all made fun of me. Y'all made fun of me last week and then didn't show back up this week. Jayden Rashada voluntarily chose to make a public commitment to UF on November 10th of 2022. Yet he had full and complete freedom to change his mind at any time before he later signed his letter of intent to attend Florida on December 21st. The Gator Collective LLC had terminated his contract on December 6, 2022. So Jayden and his professional agent still had more than 2 weeks in which to shop his services to any school or NIL Collective in the country and procure another written contract. Ugh. That Scotty accent sure makes half sound like half. Hence why I'm not saying it. He is Hugh, the owner of Velocity Automotive, or that dude. And this I agree with. This is an argument, unfortunately, for Jayden that I do agree with. The Gator Collective had terminated its contract on December 6th. Like, even though the fact that your deal with Miami might have been screwed up, it was still a full 2 weeks before you signed your letter of intent. And when you had no contract, that's the problem. So someone could say, yeah, I'll pay you. Yeah, I'll pay you. Yeah, I'll pay you. But when someone agrees to pay you money and there's no written contract, how often do they do pay you? How often when you said when friends go out to eat and they're like, yeah, I'll get you back next week when I get paid. How often do you get paid without having to ask for that money? Not very often. So that's within like a friend group. This is a college. Like, this is a college. If they're not willing to pay you, they ain't gonna pay you. Ugh. Oh my goodness. So unfortunately, like that 2 weeks, I think is going to kill this lawsuit. Still think the NCAA will take a look at it just to prevent anything like this from happening again. However, the NCAA always likes to implement rules, especially stupid ones. So I'm sure that they're going to take something out of this. I don't know if it'll work. I don't know if it'll be good. Oh, she disappeared. I hear her, but no tears so far. So she'll make her way in here. Hold on. I'm in here. Okay. Let's get back to it. Ugh. Ugh. Jayden Rashada voluntarily chose to make a public commitment to UA. Okay, read that already. More importantly, there is nothing magical or mandatory about the December 21st, 2022 signing date. It's only the first day on which recruits can sign, not the last. Accordingly, had Jayden received sound advice from his agents, he would have waited to sign his NCAA letter of intent until after a new written contract for NIL benefits had been obtained. I don't disagree with that one. I don't think his agents did him. I think his agents did him dirty. And the thing I want to know is who's paying for this? Who is paying for this lawsuit? Is Georgia paying for this lawsuit? I don't know. Whether it was with a collective associated with UF or one associated with the dozens of other schools that were also offering an athletic scholarship to Jayden. Ironically, the complaint refers to a written draft instrument entitled assignment as evidence of the monetary promises that were being made to Jayden during this time period. But the complaint fails to mention that this assignment was self-serving document prepared entirely by Jayden's agents and their attorney. It was never approved, adopted, or signed by any of the defendants, and it was merely another desperate attempt by Jayden's representatives to greedily salvage a legally terminated contract rather than to go out and mitigate damages by finding a new contract for their client elsewhere. Then again, it was the same attorney who had also drafted the original NIL contract with the Gator Collective that allowed for the unilateral termination and which contained an unagreed upon monetary amount. So perhaps that attorney was more interested in protecting himself than his client at that point. Oh, damn. Oh, damn. Like, honestly, though, like, I mean, that was very well written. Whether I end up liking this guy or not, or if he's still his lawyer, that paragraph was very, very well written. While throwing another attorney under the bus, which is always fun to read. I may not agree with it all the time, but it's always fun to read. It makes for some drama. Regardless, Jayden was allowed by his agents to sign a letter of intent with Florida without any written NIL contract in place. Yeah, that was not a good thing on his part. And then voluntarily elected to leave UF less than a month later, before any future payments could be made. How can Jayden possibly prove that he never would have been paid when his own actions rendered those payments null and void? For the sake of argument, even if the original written contract had been assigned, the same termination clauses in the contract that allowed it to be unilaterally terminated by the assigner, Gator Collective LLC, would have also allowed Hugh or any assignee to terminate it as well. Likewise, an assignment would have still required Jayden Rashada to honor his side of the contract, which he clearly breached when he chose to never show up in Gainesville in January of 2023. So as the Dire Straits song says, did he really? This is really just a case about Jayden Rashada seeking money for nothing. He really snuck song lyrics and a song title into a legal pleading. I don't think, from what I can remember, that I've ever seen that done before. 3. Conspiracy to coerce. Count 4. Count 4 involves a claim of coercion, which in and of itself against Castro Walker cannot stand alone. It was improperly stretched into a conspiracy count of coercion against all defendants jointly. For a civil conspiracy to be actionable, some separate underlying tort or wrong is required. Florida Fern Growers Association, Inc., Wright v. Yurko, Florida 5th District Court of Appeals, 1984. Wow, they really went back for that one. The defendants in this case were not attempting to commit any wrong. The defendants were merely recruiting Jayden Rashada to attend Florida. For Castro Walker, that was his job. The fact that a college football recruit may have felt pressured to sign with a particular team by that team's coaches should not surprise anyone. Once again, just because it's not surprising doesn't make it right. Ugh. Oh my God, he did it again. He's quoting movies and he's quoting pop culture. And this is an interesting reference just from who said it. As Alec Baldwin, everybody's favorite unaliver who got away with it, in my opinion. As Alec Baldwin said in Glengarry Glen Ross, the key to success for every salesman in every field is to always be closing. If buyer's remorse is now going to become actionable against any college football coach who even remotely pressured a recruit into signing with his school by mentioning that he was also considering other recruits at the same position, especially when said statement was true, then it will be the end of college football recruiting as a whole. That's bullshit. Ugh. My brother did something similar and he got paid and the position. No show doesn't mean a loss. I think it should, but morons get paid for doing nothing a lot. I mean, I can think of well, I'm just going to keep my mouth shut on that one. If you know, you know. Um, Likewise, if such pressure can rise to a conspiracy to coerce, when 5 coaches from a team visit a recruit in his home instead of just one, then the entire college football recruiting rulebook would have to be rewritten. And that is one of the things that I think is going to come from this. College football recruiting rulebook will be adjusted. And if I hear of anything or I can find anything where that happens, I will let y'all know. Negligent misrepresentation, count 5. Count 5 involves claims of negligent misrepresentation that are pled in the alternative and the aforementioned claims of fraud, with the only difference being that the plaintiff had alleged that Castor Walker should have known certain facts were false as opposed to actually knowing they were false. This is where he actually gets what was said in the complaint accurate. But this count must be dismissed with prejudice for the same reasons as count 1 through 3. A false statement of fact to be grounds for fraud. This whoever wrote this needs to proofread though, because there's some grammatical errors in here that my grammar Yahtzee side of things wants to dude, proofread. I know you got a lot to say and I know it's important and I know you're running on borrowed time, but dang nabbit. Hold on 1 second. I told her to come here and she goes, no. I was like, okay, then don't come here. Like, I don't know. Like, she's sitting outside the dining room door and she's just sitting there. Like, not doing anything. She's not trying to go for a snack. She's just sitting there. She's not crying. She's not doing anything. She's just sitting there. A false statement of fact to be grounds for fraud must be of a past or material fact, not a promise to do something in the future. Bailey v. Covington, Florida 3rd District Court of Appeals, 2021. Nothing in the future is guaranteed, so by logic, nothing in the future can be deemed a fact until after the time for it to occur has passed. Nowhere in the complaint is it alleged that Castor Walker ever made any promise that Castor Walker himself would ever pay anything or do anything. I understand where this lawyer is coming from, but also, like, I really do understand, but misrepresenting what someone else will do has to have consequences. Has to. Otherwise, everybody could be going around all day and saying, well, this person's going to do this person's going to do this. And then when it never happens, you know, I don't see that going well. So it's the misrepresentation. It's not, and the complaint never said, it is nowhere in the complaint is it alleged that Castor Walker ever made the promise that Castor Walker himself would pay or do anything. That's not the point. The point is he misrepresented what other people would do. And there has to be some sort of consequence so that people don't do that. Even in the light most favorable to the plaintiff, all Castor Walker did was predict what he thought others would do. And that right there is the problem. You misrepresented what other people would do. And you misrepresented what your boss, the head coach, would do. So you are speaking for somebody else in this case, which is a problem. Might not be illegal, but it's a big problem. That being said, whatever my opinions are on here are mine. No one speaks for me, and I don't speak for anybody else. Accordingly, for this count to stand, the plaintiff has the impossible burden of proving that Castor Walker should have been able to predict the future with 100% accuracy. a feat that even Karnak the Magnificent and Nostradamus couldn't accomplish. But more importantly, as argued previously in regards to sovereign immunity, this count must be dismissed with prejudice because on its face, it patently does not involve the actual malice required to overcome Florida Statute 768.28. Tortious interference. This one should be good. Counts 6 and 7 both involve tortious interference, which would require the plaintiff to prove that Castro Walker acted improperly to either cause a third party, Miami's NIL booster, to breach its contract with Jayden, I will be right back. I have to get baby girl a banana. My banana baby. Oh, and if you are on replay crew, I'm sorry I didn't edit that out. Get over it. Don't leave comments that says, I know you're a good mom and all, but like you leaving is annoying. If that's how you feel, bye. This ain't a fucking airport. To breach his contract with Jayden or to impede Jayden's performance of the NIL contract with Miami's NIL booster. Neither could be farther from the truth. Jayden admits in his complaint that it was his sole decision to walk away from the alleged $9.5 million Miami contract, of which no proof has yet to surface, on November 10th, 2022. Prior to this November 10th, 2022 breach by Jayden of the Miami NIL contract, the only communications alleged in the complaint to have been made by Castro Walker were, you already know what we need to do over the next few days. Get us the QB. We need to lock down Jayden. UF would want Jayden to flip this week. Nothing about these communications could be considered improper in the realm of recruiting, especially since they were made to Jayden's representatives rather than to Jayden himself. The restatement second of tort section 766, 1979 states, one who intentionally and improperly interferes with the performance of a contract, except a contract to marry, between another and a third person by inducing or otherwise causing the third person not to perform the contract, is subject to liability to the other or for the pecuniary loss resulting to the other from failure of the third person to perform the contract. A clear reading of the restatement shows that the only party who might have had legal standing to bring a claim for tortious interference would have been the third party Miami NIL booster that had contracted with Jayden Rashada, not Jayden Rashada himself. It's Kahoot. Like, oh boy. Yeah, Shani, I had somebody comment, and I don't know if they're still here. I've never seen a comment before that from them, and I've never seen a comment after. But it literally, and I'm paraphrasing, except for one part of it. It was like, can you edit out your when you take a break? I know you're a good mom and all, but I was like, everybody on replay crew, when they see me leave, they just tend to fast forward. Like, they tend to skip it. Like, sorry that my daughter comes before my YouTube channel. I apologize. Not. Like, and I'm sorry. And also, when I smell, yeah, just poof, be gone. Houdini yourself, please. Under any reading of the complaint, the only possible interpretation is that Jayden got greedy and voluntarily turned down guaranteed money in order to take what was behind door number 2. That I agree with. In today's version of Let's Make an NIL Deal, just as in the original television show, this dude has a lot of pop culture references. And I appreciate it, but it's annoying at the same time. I don't know which. Like, hey, King Paco, how are you? Oh, and King Paco, this lawsuit is in the same, it's the Northern District of Florida. It's the same jurisdiction as the other case, the other federal case we're looking at right now. Not the same judge, though. Wouldn't that be something if Judge Belitho was on both cases? In today's version of Let's Make an NIL Deal, just as in the original television show, the contestant has no legal recourse when their own decision results in them ultimately leaving with only a billy goat or a block of cheese. I'm sorry, I'm from Wisconsin. A block of cheese sounds pretty damn good. Accordingly, counts 6 and 7 must be dismissed with prejudice. Conclusion. The complaint accuses Castro Walker of fraud without sufficient allegations of fact and therefore must be dismissed for all of the grounds stated herein. Certificate of word count. I hereby certify that the foregoing contains 4,945 words. Yeah. I've had people try to run my streaming habit lately. If they go stream and be perfect, I just might start following their requests. Doubtful, but just saying. Yeah, streaming is not easy, and especially when you have a toddler. Hallie B. Lewis, Fawnville Lewis, Messer, and McConaughey. Oh, they are bored in Florida Bar. Well, that's a new one. So this is everything in this docket. So we is 40, and I'm not giving you like everything, like a motion to extend time. Y'all don't care. I don't care. So this was the motion to dismiss by Marcus Castro Walker. This was 45. But there is all this. And we are only going to go through a couple, one a day if it's long, a couple if they're short. There is there is yeah, there's a lot in this. And it went from like I checked it, I was checking it in July, and then I got busy with other things, and then like it exploded. So, but there is there's a pro hoc vice motion. There is a motion to dismiss by every defendant. There is see in this notice of appearance by Gary Lee Printy on behalf of Marcus Castro Walker. So he got a new lawyer. So that lawyer that we just saw is not his current lawyer. Motion to withdraw as attorney by Marcus Castro Walker on 11/6. Like it's just yeah. I mean, so there's a lot in this case. And then there was a proceeding held before Judge Casey Rogers, and I have to look into that judge on the 18th. On all the motions to dismiss. But he has not responded he has not made a ruling yet. So I hope that we're through all these things before he makes a ruling. Some of these, if they're short, I might actually just go through and read them and record a video reading them. That way it's not a live stream and I can just upload it a second anytime I want and we can do something else in this time slot. Because I love reading these things, but like sometimes when there's a lot to do, it's just easier if I upload, 15-minute, 20-minute videos. So on that note, I am going to make my daughter lunch and possibly change her diaper. See if we're in the midst of potty training, so like things are weird. Things aren't in the usual order that they happen in, and things are just like randomized. One day she wants to try to go sit on the toilet every day, and the next day she doesn't know what the toilet is. So it's definitely a back and forth battle right now in my house of like diaper changes or trying to go and use the bathroom. We're working on it, but we're only 2, so we're starting this process right on time. Hopefully by 3 we will be done. I just jinxed myself. But anyway, y'all have a great day. Thanks for it's a learning curve. It's definitely not one of those things that they like, talk to you about when becoming a parent. Like it's one of those things that you don't think about until it's like there. But anyway, we'll get going. Y'all have a great day. Oh, hold on. Flash Fan did ask me if I could forward or redirect to AJ. Let me do this. Customization. Redirect. Let's hope it pops up. Oh, Mo in the Deep End is live too. Geez, everybody's live. Mo in the Deep End, Nick Starro, Trial TV, Lead Attorney, Alternate Juror. There we go. Robert Gouveia. Like everybody is live. That explains it. Normally people aren't. There aren't this many people live on a Monday. So I will redirect over to AJ. And y'all have a great day. Tell her I said hi and that I sent you. Bye.